I was 5 years old when the going got tough. I remember it so vividly. Standing in the hallway, holding hands with my sis while my parents were shouting jointly. Years went by, situation got worse since my mom and dad stopped talking at the door. Now my sister and I became like some kind of toy where each parent grabbed into one of the arms. But I'm now happy, 'cause I shut myself out of the misery. Don't let it come to my head, 'cause it's not my responsibility to fix the broken dream of my family. It's not my fault and it will never be, 'cause I'm now happy, and it makes me so damn proud of me. Proud of me, proud of me, proud of me, proud of me. I was 12 years old when my daddy got told that he couldn't see us anymore. Wanted to stay with my mama, I just wanted one home, but nothing will be like it was before. Oh, but I'm now happy, 'cause I shut myself out of the misery. Don't let it come to my head, 'cause it's not my responsibility to fix the broken dream of my family. It's not my fault and it will never be, 'cause I'm now happy, and that makes me so damn proud of me. Proud of me, proud of me, proud of me, proud of me. But now I'm still trying to fix everything that we had for my sister and I. We still have a long road ahead, but she's all that I care for. No, all that I want is for her to feel happy. Oh, happy that she shuts herself out of this misery. Don't let it come to your head, 'cause it's not your responsibility to fix the broken dream of our family. It's not our fault and it will never be, 'cause I'll hope we'll be happy, and you'll say I am so damn proud of me. Proud of me, proud of me, proud of me, proud of me. Proud of me, proud of me.
Welcome to day 2 of PASG 2021. I'm Bill Burnett, the president of the Parental Alienation Study Group. I'm speaking to you today from Nashville, Tennessee, in the United States, where I am a professor in the Department of Psychiatry at Vanderbilt University. I hope you enjoyed the presentations yesterday during day 1 of this conference. Of course, the theme of this meeting relates to the prevention of parental alienation. I want to say a few words about the history of PASG and how this organization gradually came to recognize the importance of prevention. When my colleagues and I first thought about the creation of this organization, which was in 2009, we talked about the importance of having parental alienation officially recognized in the Diagnostic and Statistical Manual of Mental Disorders, and also the International Classification of Diseases. I'm referring, as you know, to DSM-5 and ICD-11. My colleagues and I developed strategies for approaching the DSM-5 task force at the American Psychiatric Association and the ICD revision organization. We published this book, Parental Alienation, DSM-5, and ICD-11, to explain why parental alienation should be an official diagnosis. As time went on, PASG grew in size and our members became interested in other aspects of parental alienation. For example, practitioners devised and published articles about interventions for alienation. More specifically, interventions for mild, moderate, and severe levels of alienation. And researchers have published outcome studies of these interventions. For example, outcome studies regarding two programs, Family Bridges and Family Reflections, were published several years ago. Even now, a new outcome study has been accepted for publication regarding the program Turning Points for Family. In addition, as time went on, we thought it was important to have a standardized and generally accepted method for identifying parental alienation. We developed the 5-factor model for the diagnosis of parental alienation, which was explained in a journal article in Ireland, that is, the Journal of the Family Therapy Association of Ireland. Also, the 5-factor model was the organizing principle of our book, Parental Alienation, Science and Law. It seemed inevitable that members of PASG would become more and more interested in the prevention of this mental condition. Of course, prevention is a step beyond the topics of including alienation in DSM-5 and ICD. It's beyond the criteria for the diagnosis of this condition and interventions. The PASG members who led us in this direction were Nick Child, David Pearl, and Philip Marcus. With their guidance, we have created the Parental Alienation Prevention Committee within PASG, and the co-chairs of that committee are Mary Alvarez and Chris Turner. So our interest in this topic will continue. As Nick Child has said many, many times, interventions for parental alienation are like rescuing drowning children from a river. But prevention programs are like moving upstream and catching the children before they fall into the river in the first place. Of course, our interest in prevention of alienation led us to this conference with the title, Protecting Family Ties After Separation. All of us who are here in Brussels today and who are participating in this conference online greatly appreciate the leadership of Olivier Van Hollen and Marie-France Carlier in creating this conference under unusual and difficult circumstances. I mentioned a few minutes ago that PASG was first envisioned in 2009. That meeting occurred in Florence, Italy, and we refer to that gathering as the Committee of Florence. Here's a photo of friends and colleagues who attended that meeting in 2009. Starting in the back row, we see Christian Doom, Benoit Van Dieren, Wilfred von Bach-Belleau, Anya Hananini, Ursula Kojo, Paul Ben-Susan, and Olga Odinets. Ursula and Olga gave presentations at this meeting yesterday. In the front row are myself and Lena Hellbaum-Jogret, Lena organized our second international conference, which was in Stockholm, Sweden. Lena is attending this conference by Zoom. And finally, Edward Bacalhar. Edward died in 2010. Since that day in 2009, this organization has grown to more than 800 members. Our members consist of mental health and legal professionals who are interested in this topic, and also parents and grandparents who are sadly alienated from their children and grandchildren. Today, we have members from 62 countries on 6 continents. We don't advertise and we don't charge membership fees or dues. Prospective members find out about PASG by word of mouth, through our website, and by reading this notice at presentations and conferences. PASG is only 11 years old. This is our 4th international conference. We are starting to plan for our 5th international conference in Australia in September 2022. I know you will enjoy the rest of today's conference in Belgium, and I hope to see you in person next year in Australia. Thank you for your attention.
Bonjour tout le monde. Maintenant,
Good morning, everyone. I'm very pleased to introduce Hans Christian Presten, so I will speak German.
Hans Christian Presten. He is a judge of the first hour. Many years ago, he was part of the. He contacted the German Constitutional Court, and he had the motion that when there is a separation, that the custody be given only to one parent. That was the rule, and he attacked that. He stated, we need joint custody, and he was the trailblazer to bring this about, namely that not one parent be marginalized and excluded. He has remained active as a family judge. He also worked as a lawyer, came back to being a family judge. So as judge, as lawyer, he has covered the whole breadth of functions, and that gave him a lot of experience on the reality in the judicial sector. And he wanted to highlight his master teachers were the children. The rights of the children, the needs of the children have always been his focus interest throughout his entire life, and throughout his entire life he has represented the needs and interests of the children. He continues doing that. Now he works with other groups in order to fight on behalf of the children and their rights, not to be violated physically speaking. So actually he is opposed to mandatory vaccination. So he is the advocate of the children and of the interests of the child. I think he's the best advocate children could wish. Thank you very much, dear Uschi, for your introductory words.
Erfahrung aus unterschiedlichen Rollen mit Ihnen zu teilen und mit Ihnen zusammen letzten Endes dann also auch Ideen zu entwickeln, Visionen zu entwickeln, wie wir verhindern können, was wir heute jetzt ganz besonders auf dem Plan haben.
And it's also about developing ideas and a vision how we can get cracking with the topic we are discussing. No. Okay. Now, what's the current situation? I think it's similar to what I experienced in 1977 when I was a young family judge. So what you observe in a small scale, you now see big scale. When I remember back, well, suddenly I found myself in family law. I knew nothing about the needs of children, and I had to make decisions as to parental custody without knowing what is the situation between the couple, what can they still deliver and what not. So I understood one thing. We as legal experts don't have a training in order to really have discernment here. And without that understanding, we are rather lost. In Bielefeld, I gathered judges and told them, this must not be. We are expected to deliver something for which we are not qualified. So we cannot do justice to what our task ought to be. So we need here a change in approach. So for 50 years I've been dealing with these questions and issues. And it was always about the situation of children facing situations of separation. But not only in such separation. Whenever the state mentioned and thought that they have to intervene as a state in the parental rights, I was active. You heard about my motion to the German Federal Constitutional Court, and there is a reason I did that. It was an early experience that raised my concerns, and I made certain that the judges in the town of Bielefeld at least got some extra lessons from 2 psychologists. And they told us right at the beginning, you are legal experts. If you want to talk to children, you cannot talk to them if you do not understand what the terminology is about, the well-being of the child. And I was told, don't get them to court, because when they give answers in court, you cannot rely on these answers. They will deliver what the father expects, or what the mother expects, or what the judge expects. And it's such a burden on the children if they find themselves in court. Go and meet the children at home. And I said, I'm a judge, I cannot go to the houses. If I visit the child, maybe the mother has to be present, but the father is outside. I'm biased. Okay, or with the child alone, yes, might be an idea. And I dared go to the houses, go to the homes. I talked with the parents, I talked with the lawyers, I got an invitation, and both parents had to go out. Was not easy. My goodness, I was nervous. I entered uncharted territory. And it was interesting to observe the children, to see them act and react. That was incredible. I started with the assumption I can make an easy decision. I can regulate custody and contact. But I understood now, if that is my decision, it would not be better for the children, because I also have to see what happens between the parents. Are they still at war with each other or not? And I concluded, my job is to protect the child. My job is not to mollycoddle the parents. So we have to see all aspects of the situation, and I decided to bring in experts, advisors, who reserve their time to talk to the parents, to find out if the parents can refine their role as parents together. So that was also the background why I contacted the German Constitutional Court in order to work more towards joint custody. And I can tell you, in all my years of experience as family judge, it was never necessary to embark on coercive measures to convince the parents. Now the question. The situation still remains difficult. Why is that the case? And our legal system seems rather helpless to this day. so that we have colleagues as family judges and they work based on wrong assumptions and have to use wrong instructions. So imagine you have a judge and rather at the outside, rather at the surface, he has to make his decisions. Imagine a parallel. We take our car to the garage because the oil lamp signals a problem, and all the mechanic does is take out the oil indicator. So the legal instructions are still designed in such a way that they just look at symptoms. And that is not a good support for the judge's decision in order to really protect the needs of the children and the rights of the children. Needs of the children and rights of the children. Those are my two buzzwords. And obviously, this is not really reflected in the legal text. So the legal text talk about the well-being of the child. But allow me to give you some background information as to the foundations for all of us, not just in Germany, but internationally speaking, we have a foundation. And it's not very complicated to talk about this foundation, and I want to start with that. So the basic rights, the fundamental rights, I hope I can show you what I'm referring to. The fundamental rights of the children. And on the 1st of April 2008, the German Constitutional Court highlighted that as well. Allow me a quote. The child has its own dignity and its own rights. As a bearer of fundamental rights, it is entitled to the protection by the state and the guarantee of its rights guaranteed by fundamental rights. A constitution which places the dignity of the human being at the center of its value system cannot, when ordering interpersonal relationships, in principle grant anyone rights to the person of another which are not at the same time bound by duty and respect of the human dignity of the other. This also applies to the relationship between a parent and his child. The parental right is therefore inseparable from the duty of parents. This means the child is entitled that the parents take care of it. So parental right involves always parental duty, duty that has to be respected. And Article 2 as well and Article 1 highlight these various aspects because this ensures the family tie, the family relationships to the child. The parental relationship, their care, are very significant in order to make certain that the child can develop into a personality that is respected for its own right and does the same to others. These are basic fundamental legal texts. They talk about rights of the children, and that is not vis-à-vis the right of the parents, but the duty of the parents is the vis-à-vis. So we have to be careful when we use our terms. Shared custody often may imply a right given to the parents. No, it's a right enjoyed by the child. And there are international texts. And they are to be applied as valid legal texts in Germany and in many other countries. They highlight the very same aspects, and they give us an option how to define what is still lacking. So, we often face that the rather authoritarian judge makes decisions on the life situation of parents and children and lacks the tools to do a sound decision. And now, the UN Convention on the Rights of the Children. Article 7, Passage 1. The child shall have the right to know and be cared for by his or her parents. Article 8. States parties undertake to respect the right of the child to preserve his or her identity, including family relations as recognized by law, without unlawful interference. And now an aspect which we haven't really been seeing yet. Where a child is illegally deprived of some or all of the elements of his or her identity, states parties shall provide appropriate assistance and protection with a view to re-establishing speedily his or her identity. Think about this. And Article 16. No child shall be subjected to arbitrary or unlawful interference with his or her privacy, family, home, etc. And we read, the child has the right to the protection of the law against such interference or attacks. And Article 19. State parties shall take all appropriate legislative, administrative, social and educational measures to protect the child from all forms of physical or mental violence, injury or abuse, neglect or negligent treatment, maltreatment or exploitation. And Article 37. The states parties shall ensure that no child shall be subjected to torture or other cruel treatment, etc., etc. These are fundamental legal texts upholding the interest of children and how to understand the needs and rights of children. And this is to be seen not just by the parents, but by all of us. We as a community, we as a state have to do our level best, everything possible to make certain that parents and the families are given the best of support, whatever is necessary in order to tackle their duty. If you look at the legal text, it's like a bit of a non-starter or a bomb that didn't explode in the war. We are often not conscious of this, but we often find these aspects. These are like unexploded bombs, but we step on them and then we have an explosion. Now, why do I express it this? Just look at the German Civil Code. So if parents live separated for a certain time and are entitled to custody, then it can be requested that the family law give the custody to only one parent. And this has to be granted as soon as the other parent occases, or if the child is at least 14 years old, or if you can be is to be expected that this decision serves best the well-being of the child. The well-being or the interest of the child. How can be something there that serves the well-being of the child best if at the same you violate a fundamental right of the very same child? So I see here a contradiction. And I would say this is like an invitation to the court, if the parents are still at war, etc. Let's get cracking and do something here. So the court is invited to intervene in the competence of the family and to make a decision that is a lasting one. And what else happens? So one parent alone enjoys custody, or even visiting the child is limited to some hours or some days because there is a consistent conflict among the parents. What do we observe? We observe the following. The child loses the important ties to the absent parent, still necessary to develop his own personality, and the child also loses 50% of his guarantors, of his potential guardians. You might have the parent with custody who is ill or can no longer do the job, and then family members should be called on first to take care of the child. But the family ties to the marginalized parent is now a problem. And if there's an ongoing conflict, you cannot expect that someone has the idea the grandparents, the aunts, whoever is there as a relationship could be included. And here also the German Federal Court has decided, has underlined the importance of family ties. And there was a grandmother who came with a complaint, and quite rightly so, because she, the grandmother, was not considered as a caregiver to her own grandchild, and it was placed in foster care. And the Constitution all talks about the protection of the citizens whenever there's an infringement or violation of fundamental rights. Namely, the state has to follow the principle of proportionality. Already in 1968, we have a decision by the Constitutional Court. I have to press here the button. Decision on parental behavior. This does not mean that every failure or negligence entitles the state to exclude parents from care and education, even to take over this task itself. Rather, the state must always take into account the fundamental primacy of parents. And here the principle of proportionality also applies. Nature and extent of the intervention are determined by the extent of the failure of the parents and by what is in the best interest of the child. So how you best serve the right of the child, I would put it. The state must therefore try, as far as possible, to achieve its aim by helping, supporting measures directed toward the establishment or restoration of responsible behavior on the part of the parents. Now, how can we combine this? So proportionality obviously doesn't seem to be a big deal when you decide on custody questions and visitation rights. And at the same time, we are Article 19 in our German Constitution. We read, in no case may the essence of a fundamental right be affected. The essence of a fundamental right must not be affected. Please give that some thought. The child has a fundamental right to enjoy both parents, and here that fundamental right is violated for good. And another aspect, we have Article 1 of our German Constitution, which applies generally. The human dignity is inviolable. Human dignity means wherever it's about the rights of the human being, you have to see the entire human being. Please, not just limit yourself to a formal hearing. That might be sufficient when you're talking to adults, but it will never be sufficient when you're talking to children. So there must be the option to bring in the whole personality to influence the proceeding, to come across to the various actors and players, like the judges, like the social workers, etc. Now, I mentioned to you that I went to the homes of the children, and that was an eye-opener. When being at home with the children, they give different signals, generally speaking, different signals with regard to their preferences. A 3-year-old girl getting onto the lap of her mom and take the necklace of the mother to give it to the father, or a young girl who was very silent, and when I leave with the father, she just cries, "Daddy, stay." When you observe this, when this becomes visible to all parties involved, including the judge, then something happens, and Professor Klemmer describes this. This is the moment where the parents no longer are innocent warriors, because they have realized what it really means to their child. That's a change of climate, of atmosphere. And it also means that the parents have a significantly enhanced willingness to get advice, to be counseled. So now you can work with that and give it some time and check after a certain moment to understand How are the parents dealing with it? Hearings. So how does it happen? It's just a hearing. It's a verbal questioning in a strange environment. So it does not look at the concrete personality and abilities of the child. It means the child does not have the opportunity to really show and express himself or herself, verbally and non-verbally. And it is not seeing really the potential negative impact certain decisions are going to have. And it often creates feelings of guilt in the child. This is an added hazard for the health of the child. And what does Article 1 of our German Constitution states? The human dignity is inviolable. What about the child's human dignity here? So it's about the rights of the children, it's about the rights of the families, and it's not about egotistical expectations which you may have at a certain moment. It's important to be aware of this in order to ensure a healthy development for the child, where it also develops a healthy self-esteem and understands that it has importance. Now, the consequences. I try to give you an idea here. I would state as following. Something is absolutely necessary that needs to happen. And it's a challenge. Psychology, pediatrics, humanities, and legal professions, legal sciences, have to be fused, have to be merged. It needs to be part of the approach by the judge. We cannot expect that the judge will know it all, but we need here a properly designed advocacy on behalf of the children. And it needs to start in the parliaments. When was it? 2016. I talked to the Child Commission of the German Parliament. I described the situation of children in Germany when facing court proceedings. And I had a lot of statistical material to back me up, namely to show how dangerous the impact can be, and usually is. And it's not just the children and the families who need a representative, and that might be rather a random choice sometimes. No, what they need above all is the following. The parliamentarians who make the laws have to get acting. They have to be aware that the legislation needs to be aware of the children's rights and interests. So we have parliamentarians who are incompetent. We need to overcome that incompetence. So they need good scientific input. And let's face it, parliamentarians come from all walks of life, but they need to get this input I'm talking about. And a parliamentarian, first of all, has also to view the executive, which has to execute the laws made. And laws are not designed to stroke the ego of the executive. Laws are designed to protect the people, the citizens, because the citizens are holding the power, not the government. So the parliamentarians making the laws need skills, independent of their political affiliation. They need input, they need advice. And they need concrete rights of initiative as well to check incoming legislation and maybe review existing legislation. And I also put this in writing, which probably will be made available to you. I have a whole list of recommendations. So there is definite urgent need for action on the legislative side. If we truly want to achieve a democratic situation where the three branches are truly separated power branches and control each other. So thinking of the judicial side, there are problems there as well. The judge simply is not prepared to understand the psychological and mental needs of children. The judge is not even qualified to see these needs. The judge is very dependent on the expertise, on the opinions coming from third parties. So that may be rather randomly chosen so-called experts in some cases only. That should not be. So it's very, very necessary that we see some action, that we see some change. In order to protect children and families, we need to organize a representation or a representative where you have both elements merged, where you have sound support for the judge and for the court, in as much as such support and help can be done. And there are other conclusions and consequences. For example, the children's advocate the parliament has also needs to be seen. That needs to be the right person. That needs to be a person, or rather a group that is truly independent. They need to be true advocates, and they need to work towards having advocacy options where people are, and to offer that free of charge. Whenever there is a conflict, whenever there is a crisis where you infringe in the rights of children and of families, you need this institution where it happens, ready to act, to give advice to the family, to support the child, and to make certain that they are represented. And something else is necessary. When you think of the legislator, we need to create the following situation, where formal laws are being reviewed. In other words, we often think of a mere functionality of the courts. They just look at the symptoms. We must overcome that. I think there is interesting work ahead. It's very necessary to do this because there is a lot of dust that has settled on a lot of legislation. So we need to shake that up and review it and change that, adapt that, in order to set the focus on the rights and interests of the children truly. So quite a few implications, quite a few conclusions that are ever more necessary than before. Why do I say this? We have corona measures. And the assumed existence of a virus where we see the need to fight, to engage in battle. So it's already the warrior language used. And it's a measure that is dictated from the top down. Though it's not the judge, but it's the state, the government, that dictated to all of us, making all of us little children who have to be obedient to the state. So if you look more closely at it, and I also had to deal with penal law, this is one thing in my understand. It actually violates a penal code. For example, the German penal code, if it's about a person younger than 18 years in Article 225 of the Penal Code, if you endanger their health, create negligence, etc., then you will be punished with prison. Or if the perpetrator engages in an act where the person is close to danger of dying or of suffering bodily or mental harm of a lasting nature, then we face the following situation. Hüter is a brain researcher, and he explained this. Here, one of his books, and especially his contribution, Pathways Out of Fear. Now, finally, two books, allow me to refer to them. Bruce Lipton, a cell researcher. I think that is something helpful to rediscover ourselves and to leave behind us this position as mere children. And I think that's very interesting and engaging with regard to attitudes towards health and illness. And he gives research on how our experiences also impact our genes. Another book reflecting a Congress in Düsseldorf, Separation or Divorce Hurts. And finally, from Mr. Hüter, a little bit more brain mass, please. So that's what I wish for all of us. Thank you very much for listening to me. Thank you for having invited me, and I look forward to the cooperation which hopefully enables us to put into practice a few of these ideas.
Danke, Hans-Christian Pristine. The next speaker is Marc Juston. He's a French judge which has almost more than 30 years experience with parental alienation in France. Unfortunately, he's one of the only judges in France who had these insights, and he's going to do an explanation about that.
Bonjour à tous et à toutes. Je voudrais remercier les organisateurs de m'avoir invité, Monsieur Olivier Van Allen et Marie-France Carlier. Je ne vous cacherai pas que j'aurais bien aimé travailler avec Marie-France Carlier. Malheureusement, nous ne sommes pas dans le même pays et nous n'avons pas le même âge, donc nous n'avons pas pu travailler ensemble, mais on a réfléchi ensemble. Je voudrais aussi remercier tout le travail effectué en France.
Oh, sorry. I would like to thank everyone for the work on parental alienation under the chair of Olga Ordinez, which is a huge investment that enables to think together in an efficient way on parental alienation. So I'll try to be short in 20 minutes. It's true that full conferences could be devoted on the children's narrative. So in 20 minutes I can't be very precise. So I've been a family judge and a children judge for many years, but I also chaired the higher magistrates court for some time. I'm a retired honorary magistrate, and there is a victim, a forgotten victim in family judiciary, namely the child. Most of the time the focus is on the parents, but the child is forgotten, is hidden. He's the hidden victim of separations and divorces. And the reason why I still speak out is to denounce that victimization of the children. So hearing the voice of the child and thinking about parental alienation is indeed a very complex and difficult issue that embarrasses, so to speak, most family court judges. So the child narrative, the word of the child, and parental alienation is a tricky issue for many family court judges, even though these are the two most rewarding aspects of the job. You know that in the context of conflictual separation or even a situation of parental alienation, the courts rules on the basis of the elements brought to their attention, and the opinion of the child gathered during the hearing is one of these elements. The child is a discerning person, and so the judge has often to listen to the child's opinion. From the moment the family court judge I'm using the acronym in French, the JAF. The JAF is the family court judge. So from the moment the family court judge participates in manifestation of this element, it is up to him or her to ensure that the child's word is obtained in the best possible conditions, that it is an exact, complete and objective reflection of the child's feelings, and that the hearing of the child is detached from any influence that any of his or her parents may have on him or her. So that's the theory of a hearing. But in practice, the child's right to speak is not without question, particularly in situations of parental alienation. The process of hearing the child is in fact very fragile. Practitioners always have to find the balance between the respect for the children's right to speak and the necessary protection of which the child must be object. And because in parental separation there may be situations of high conflictual relationships between the parents. So how to find the right balance between this right for the child to speak and the protection of the child. So here I could refer to International Convention on the Rights of the Child of the 20th of November 1989. The Article 12 of this so-called New York Convention establishes the right of every minor capable of forming his or her own views to be heard in any judicial or administrative proceedings affecting him or her, either directly or through a representative or an appropriate body. So that's Article 12. And France ratified this convention in 1990. And so this convention is now enforced in France. Today we are in Brussels, so let me also say a few words about the recommendations put forward by the ministers of the Council of Europe. In 2010, the Committee of Ministers of the Council of Europe unveiled its guidelines on child-friendly family justice. So there are very interesting recommendations. I really recommend you to have a look at those recommendations that are often forgotten, unfortunately. So let me highlight a couple of those recommendations. The Committee of Ministers in particular emphasizes the best interest of the child, or the right of the child to participate in the proceedings, to be informed of his or her rights, and to have an appropriate access to justice. The Council of Europe calls for a special effort to be made to train professionals, and that's important, and also that a special effort to be made to adopt a multidisciplinary approach. Last but not least, the Council says that the right to be heard and to express one's view is proclaimed as a right of the child, not a duty. And it warns that the children's testimony should be received in a manner that is conducted by qualified professionals. Furthermore, in 2011, the European Commission launched a program for the rights of the child. It's recalled in particular that the rights of the child are fundamental rights. Every state must ensure that these rights are protected and that the best interest of the child guides its actions. In particular, a more child-friendly justice system must ensure that children's rights are taken into account whenever they come into contact with the judicial system, when their parents divorce or disagree about custody arrangements. And the European Commission suggests that consideration be given to the establishment of a specialized judges and lawyers for children. So, how to integrate Article 12 of the New York Convention and the recommendations of the Council of Europe into the French law. There are some legal provisions in France, and so you can find some articles in the Civil Code, but true to say that those articles are not very detailed, and a great deal of latitude is left to each family court judge to set up the system that he or she considers to be the most protective for the child. And so this great deal of latitude means that each JAF, so each family court judge, has its own way of working. So depending on the court you attend, you might have different proceedings, different ways of implementing those principles enshrined in the New York Convention and in the French law articles. So that's a reality. So the judge has a great margin of maneuver. The family court judge must ensure that the child has been informed of his or her right to be heard and to be assisted by a lawyer. the child is a subject of law. So the child should be a discerning child without any particular form. Some judge will say that a discerning child should be 8 or should be 10 at least or 12 at least. And in this, against this background, there is a case law that is often forgotten in the case of an acute coupled dispute. The consent to protect the child from the parental conflict may justify the refusal by the judge of the request for a hearing made by one of the parents. So the hearing can be rejected by the judge from the moment he considers that the conflict between the two parents is too intensive, and this intensity of the conflict between the parents might disturb the hearing of the child, even though it is a discerning child. So this is a ruling by the Supreme Court in France, and I think that 90% of the family judges in France have never heard about this ruling. It should be noted that the conditions under which the judge hears the child are not subject to a precise legal framework. It's up to each judge to determine, in the light of the circumstances of the case, which specific arrangements for the hearing are most suitable. Most children, in this case, will be accompanied by a lawyer, by a solicitor. Whenever there is a child hearing, there should be some writing about what was said during that hearing. It's not really; these are not really minutes, but it's rather a kind of a note-taking that is then passed on to the lawyers. And so the idea here is to respect the right to speak of the child, but also to protect the child. How to protect the child from the moment the child has a few things to say, and if he says a few things that are negative about his or her parents, we should make sure that the child doesn't become the victim of violence, of retaliation by one of his parents due to what the child said during the hearing. So collecting the child's views is a major advancement because the child is a subject of law, but there are some risks entailed in the hearing of the child, and those risks bear some potential hazards for the child. So there is a need to think about the best interest of the child, but during the hearing the child becomes kind of a referee, the one who will influence the ruling made by the judge. The judge will probably rely on the child's views to make up his mind and to issue a ruling. So against this issue of the hearing of the child, what kind of attitude do family judges have? Generally speaking, the judge himself or herself will hear the child directly. And in line with the civil code, some judges will delegate the hearing to a third party. He can do so to an expert in medical or psychomedical matters. The third party that is doing this hearing will be paid 50 euros. Do you really believe that as part of an intense conflict between parents, a good hearing can be carried out in 50 euros? That's not serious, frankly speaking. How can a hearing be made in good conditions for the child when the expert is paid 50 euros only? The hearing can be done through a social investigation also, and there is also the child's condition. What does that mean? It means that the family court judge and a third party, a psychologist, a family mediator, a third party who is quite aware of child psychology, two experts, in other words, will all look at the condition of the child. And this practice was rewarded by the Council of Europe and by the European Commission. It was given the award of the second prize at the Crystal Scales of Justice Prize, rewarding innovative practice. The co-hearing, because that's the name that is given to this procedure, the co-hearing allows the minor to know the family court judge who deals with the case, and the latter to know the entirety of the child's words, unlike the collection of the word by a third party only. So co-hearing allows for teamwork that takes advantage of the values and the experience of each profession and restores a form of collegiality. So it's very important that the child is heard not only by a judge, but also by a third party. Finally, the child can be heard in the framework of a family mediation process for which the parents have accepted the measure. So, in the face of parental alienation, let me focus on 5 major issues. Discernment of the child. That's the most sensitive subject, which for the moment is not defined by the law and is not satisfactory. Depending on the judge, the practice will vary a lot. Again, discernment is not a matter of age. The Supreme Court has issued 2 rulings in that sense. In a first ruling, the Court of Cassation censored the decision of the Court of Appeal, which limited itself to referring to the age of minor, 9 years, without explaining in what way the latter was not capable of discernment. So, of course, the child is not heard, but it's not a matter of age. And in a second ruling about the discernment of a child, and this is an interesting case, a Court of Appeal had noted that the child who was not yet 9 years old, and the country letters she had written at intervals of a few days showed that this child was subject to pressure from her parents, and this was enough to verify or to confirm the absence of discernment. So various elements can determine whether the child is a discerning one or not. So, and also to make sure that the hearing is taking place in an objective way. A judge should always ask him or herself what is the degree of freedom of the child. The judge should look at the freedom of the child as part of the possibility of parental alienation, and also to wonder what is the usefulness of the measure. So, in particular, if his point of view has already been taken into account by means of some medical psychological examination of social inquiry. Unfortunately, judges are entangled in qualitative requirements, and they can hardly do qualitative work. It is important, however, not to lose sight of the fact that the children's freedom can also find expression in the fact of refusing to be heard, or keeping silent, or changing one's mind. So much for discernment. The second issue in children's hearing is the lack of training for family judges and lawyers. I'm retired now, so I'm free to say whatever I want. So without elaborating on them, too many practices are ethically unacceptable and do harm the notion of the best interest of the child. So some practices are harmful in terms of the best interest of the child, because family judges are not properly trained. So the judge will ask the child, why don't you want to go and live with your father? Why do you want to go and live with your mothers? Well, these are questions that date back to the 19th century. Gathering the child's narrative, the child's views, especially in situations of parental alienation, is not an easy task and requires the development of both technical and relational skills. In particular, this exercise requires professional skills on the psychic development of the child. The judge, like the solicitor, the lawyer, is essentially a jurist, a lawyer, so he carries out his profession with respect for the human being, but a judge is not omniscient. So is the judge or the lawyer best placed to gather the views of the child in cases of parental alienation or conflict of loyalty? A third issue, I think it would be good to strive for uniformity in the practice of hearing children. This diversity of practice is bad for the child's interest. Some lawyers are doing their task very well, but sometimes the children are instrumentalized. Let me give you two striking examples which will be eye-openers of the harmful aspects of such hearings. First example, first the lawyer who was refused a hearing by a judge because of the child's young age had another lawyer hear the child who wrote a report on several pages. Similarly, another lawyer had a 6-year-old child interviewed by a lawyer prior to the child's application to a family court judge. Such practices are outside the code of conduct. A fourth issue is the empowerment of parents and the respect of co-parenting. Let me quote one sentence from a report of the Children's Ombudsman, who recalls that adults may hide behind the child's expressed wishes to avoid their own responsibilities or to make their own point. In such situations, it means that children should not be in pole position and parents should be empowered. When listening to the child, and especially in cases of parental alienation, justice stakeholders need to be more vigilant and to take care of the child's best interest. They should ensure that the child's hearing is taking place in safe circumstances. The child should not be an instrument used by parents to take revenge over the other parent. The child is not forgotten in these separations, nor the victim of the ill treatment of some stakeholders. Every child is entitled to co-parenting, and I'm pretty sure that if all professionals did engage to gather the children's narrative and views in the sole best interest of the child, in that case, it could be a tool to combat parental alienation. Last, I would like to recommend all parents to watch the video that we all watched yesterday, because it's a very realistic movie. In the case of video, the alienating parent was the mother. It could equally be the father. But I think that it could be an eye-opener for many parents and make them realize all the harmful consequences their attitude can have on the child. Thank you.
Okay, so thank you, Marc Juston, for this very interesting explication. I think the importance is that if we hear children, that the way we hear children, it's not only hearing, but also listening what they have to say. The next speaker will be Jan James. She's CEO of Good Egg Safety, a non-profit organization in the UK, and also activities outside. She has a lot of experience about the healthcare and the problems with families.